Hi, I'm Daniel Findling with Findling Law and thedivorceguy.com. Every tax season, a question that often arises is how do we handle the dependency exemption or the child tax credit for divorced or separated individuals? And there are different rules depending on where you look. From the IRS perspective, you can only claim a dependent on your tax return if you meet two qualifications. First, that the child spends more, or the qualifying child, to use IRS language, spends more than 50% of the time with you. That's 182 and a half overnights. Second, that you provide more than 50% of the support for the minor child. If you meet those two conditions, you can take the dependency exemption or the child tax credit for that minor child. However, in Michigan, there's a case specifically called Fear versus Rogers, where the Michigan Court of Appeals said, notwithstanding the IRS rules, a Michigan court, can award the IRS dependency exemption to a non-custodial parent, or that is a parent that spends less than 50% of the time with the minor child, or provides less than 50% of the support for that child for a year. It's important to understand that both parents cannot take the same dependency exemption in a year for divorced or separated individuals. So which rule applies? Well, the answer is the state rule applies if, in fact, a state court orders it. Okay? If there's no state court order, then the federal rule applies. And the impact can be very meaningful. For example, if you are the payer of child support and now your income is increased because, at least your free income, because your taxable income has gone down, you may be paying more child support, but you'll get the dependency exemption that may offset that, and vice versa. So the key learning here is as follows. When it comes to the dependency exemption and the child tax credit, it's important first to consult with your certified public accountant, and second, to have an understanding of both IRS Publication 504, which is the IRS publication regarding divorced or separated individuals. And that'll go into greater detail about what is a qualifying child, which is a whole other set of rules. Also have a thorough understanding that Michigan provides that a court can award the dependency exemption notwithstanding the federal rules. Now, if there's no agreement, if there's no order from the court, then the IRS rules prevail, period. Let's say that you're in an instance where both parties take the exemption and only one person was allowed under state or federal law. Well, there's Form 8332, which is revocation of exemption that one party would have to fill out, which revokes the exemption that they took on a tax return. If they don't do that voluntarily, you can always go to court and enforce that to the extent that it violates a court order. I'm Daniel Findling with Findling Law and thedivorceguy.com. We'd like to welcome you with any questions and have a wonderful day. Thank you.